Good morning. Hello and welcome to this installment of the Pro Bono Partnership of Atlanta monthly webcast series. I'm Sarisha Ganta, Counsel and Education Director with PBPA. Today we have Lisa Mortower from Berman Fink Van Horn speaking with us. Lisa concentrates her practice on state and local government law with a focus on alcoholic beverage licensing and hospitality law and zoning and land use matters. We are thrilled that she is joining us today to talk about Zoning 101. Before Lisa gets into the substance of today's presentation, I'd like to tell you a bit more about PBPA and our mission. PBPA provides free business legal services to Atlanta area nonprofits. We do this by connecting the nonprofits with volunteer attorneys from Atlanta's leading law firms and corporations. PBPA provides direct legal services to our clients. We also provide free resources to any interested nonprofit through our website and in-person events. Who are our clients? If you go to our website, you'll get more information. Our clients are all 501c3 organizations that are located in or serve the greater Atlanta metro area. And by greater metro Atlanta area, it's a pretty broad definition. Our clients serve low income or disadvantaged individuals and are otherwise unable to afford legal services. Also on our website, you'll find more information about our free resources. These articles, webcasts, and podcasts are available to anyone. And we do plan to have an in-person workshop this fall, the first one since March 2022. Now, please keep in mind that today's presentation and any questions that Lisa may answer today is not legal advice, it's just general information. Please reach out to an attorney to talk about your organization's specific needs. Also, today's presentation will be recorded. The presentations and slides will be available on our website in a few days, but keep in mind that today's presentation is copywritten. Now, Lisa, I'll give the floor to you so that we can talk about zoning.
Good morning, everyone. Thank you, Sarisha. I am thrilled to be in front of all of you today. As Sarisha said, I'm a zoning and alcohol licensing primarily attorney, and I love talking about zoning. I think it's so important for organizations, property owners, regardless of whether or not it's a nonprofit organization or a for-profit organization, to understand the issues that arise when you're dealing with land, either signing leases, purchasing property, or even getting a donation for some structure or something like a trailer that's going to sit on your property. So I will try to guide you as best as I can through the process. This applies to all of the metro area, but I do tend to talk about Atlanta more often because I'm a former city attorney for the city of Atlanta. So I deal in Atlanta a lot, and Atlanta is a really good example of the kind of complicated process that you have to go through for zoning matters, but I will reference some other cities or counties as I move along. If you have questions, please, I will answer them at the end. I don't think I'm gonna stop to take questions. I think I'd rather get through the presentation first because it's very long, and I might have to kind of skip through some things as we're moving along to make it time sensitive. So if you have questions, I'll try to answer them at the end if there's enough time. And if not, you could email me and I'll let Sarisha give you my email and you can send me an email and I'll try to answer it. So with that, I'll start. It's the title, the first section is called Determining the Zoning Classification of Property and the Allowed Uses for that Property. And that's the very first thing we need to do when we're looking at whether the use you want to use the property for is allowed. So I'm going to ask Randy to turn the slide every time I'm through with a slide. So the first thing I want to talk about is how zoning came to be in Georgia. So under the Georgia Constitution, there's a right that's conferred to every county and city to regulate the land within their borders. And it includes the types of uses and the development that's allowed on the land. And they are allowed to enact zoning and land use laws and regulations. This is called the home rule power, and the Georgia Constitution specifically sets out a statute regarding planning and zoning, and I've got it right there. It says the governing authority of each county and of each municipality may adopt plans. Oh, it's moving forward, and I need to stay on that screen. The second screen, yeah. So the one right before that. So the Georgia General Assembly provided authority to each of the governing authorities in Georgia. So you've got counties and you've got cities. And each one has their own set of laws regarding zoning. Now, that doesn't mean that the state doesn't limit that power. There are some things in the state law that the Georgia General Assembly has enacted that do put limitations on the authority of local governments to regulate land. And one of the things that they did is enact an ordinance called the Georgia Zoning Procedures Law. And there are other ones, but I just mentioned that one because that's the main one. I'm ready for the next slide. So what does zoning actually mean? Under state law, and it's in that zoning ordinance, the zoning statute I just referenced in Georgia state law, zoning is defined to mean the power of local governments to provide within their respective territorial boundaries for the zoning or districting of property for various uses, the prohibition of my camera's in the way of some of my words, of other or different uses within such zoning or zones or districts, and the regulation of, and I'm sorry, I'm having to move around, and the improvement of real estate within the zones or districts in accordance with the uses of property for which such zones or districts were established. I'm ready for the next slide. In layman's terms, zoning is the process by which a local government divides its land into districts for different uses using its legislative power. The local government passes laws to do this. And in these laws, they establish the various zoning districts. They give them titles. They regulate the uses for each district. So when you look at a zoning code in a city or county, it will have a list. It'll say the district, and then there will be a list of the types of uses that are allowed by right in that district. And then it regulates the structures to be built on that land. These laws are typically enacted with an eye of protecting the health, safety, and welfare of the general public. Those are the key words that are always found in ordinances written by the local governments. And the local governments are trying to, when they do these ordinances, they're trying to place compatible uses near each other, and they concentrate incompatible uses away from each other. So for instance, a government can try to keep industrial use away from nearby residential use. And that's the way they will lay out their districts. I'm ready for the next slide. In trying to accomplish compatibility of uses, cities and counties use zoning laws to establish the law on how the city or county will grow. And then once it divides the city or county into districts, the next step is to enact laws which regulate each of the uses, as I said. So there will be categories of commercial use, residential use, agricultural use, mixed uses, and then the types of buildings and structures that can be constructed within each district. And in those specific ordinances, there will be regulations regarding the size, the number of stories, the height, the configuration of the building, setback lines, and that's the where part. Where are they going to locate structures on specific pieces of property? So they use setback regulations and green space regulations, and there's other ones that keep the uses separated from each other, and to make sure that the buildings are built in accordance with how the local government wants to build them. They also use other measures such as buffers, flood controls, and as I said, setback lines. So zoning laws allow for some flexibility to conform to inevitable changes in the community under certain circumstances. And we're going to talk about how there's flexibility in a moment. I'm ready for the next slide. But these laws are all enacted, and they're almost always called the zoning code or the zoning ordinance of, and then the city or county's name will be there. So they typically come under a chapter of or a whole section of the laws enacted for the local government under the zoning ordinance laws. And then state laws, as I said, give each local government a tremendous amount of power to establish these zoning laws with the limitations that we mentioned before. Ready for the next slide? And as the city or county is enacting these laws, their code of ordinances, they're required to set forth what is called a comprehensive plan for future land use. So every city or county is required by Georgia law to enact a plan that shows what they want their county or city to look like in the future, maybe 10 years from now, 15 years, or 20 years from now. But there's certain laws about that. I did not give them to you because you don't really need to know them, but there are every county and city has a plan for their future growth. I'm ready for the next slide. How does all of this impact your organization as a nonprofit? Well, the organization must determine what zoning district a piece of property is in before you decide to sign a purchase agreement or a lease agreement, or as I said earlier, accepting a donation, such as a trailer. If you are about to open up an office somewhere, or if you want to use your property in a certain way, you have to understand the zoning for that property before you do anything. The steps for researching zoning for each property are pretty simplified. You use the address, determine where the property is located. So you want to know if it's in the city limits of a specific city in Georgia, or is it in an unincorporated part of a county. You can use a GIS map if the city or county has that on their website. Some little tiny cities in Georgia do not have the GIS map information, so you have to contact the city or maybe even a county. Some of the least populated counties may not have it as well, but I've found most of them do. So if you plug the address, you go into their GIS map on their website and plug in the address, it should pop up the information you need about the zoning for the property, and it will tell you if it's in the city limits or the unincorporated part of the county. So then when you do that GIS research, you can determine the zoning classification for the property. And once you have the zoning classification for the property, you have to turn to the zoning ordinance for that county or city to determine whether the uses that you are contemplating for that property are allowed. You will look to see what the uses are for each zone for that particular zoning classification and determine if it's allowed by right, or do you have to get a special permit, or is it prohibited outright? Those are key questions once you know where your property is located and what its zoning category is. If the use is not allowed by right, what does the future comprehensive land use plan say about that land? So that's where that information I just spoke about, where the state requires each local government to have a future land use map. When you're looking at the zoning, and if it doesn't align with the use that you are trying to use the property for, then you have to look at what the future land use plan is for that property. And local governments really want to stay in line with the future land use map. It's not in most jurisdictions, not all, but in most, they are not bound by their future land use map, but they usually are guided by their land use map. I'm ready for the next slide. So now we have to understand how you navigate the procedures for rezoning property. If there's no right to use the property the way you want to use it, and it's either prohibited or there's a lot of hurdles, you might want to do a rezoning of that property. So what is rezoning? Rezoning is the reclassification of property or an entire area of properties to a different zoning district, or the reassignment of property to different zoning restrictions. Rezoning authority is vested in the local government, either the city or the county, and is the result of the need for the government to be flexible and to respond to significant changes in the community. Local governments do recognize that rezoning of land sometimes is very beneficial. And case law in Georgia has made it clear that factors such as community growth, the economy, new development, and improved technology may require that land be rezoned so that the community can meet the needs of these changes. I'm ready for the next slide. For rezoning property, it's a pretty complex process. And I'm going to use the City of Atlanta's process, but most governments have a very similar procedure. But in Atlanta and almost everywhere, you have to meet before you file a rezoning application. You have to meet with the staff in the planning department for the local government. And in Atlanta, they have a separate committee. It's called the Concept Review Committee. And they also have planning staff, but you have to meet with the Concept Review Committee prior to filing your application for rezoning. And a rezoning application is very complex. I don't think I've got an actual copy of it up here on the screen, but I'll go through the parts of it. So you also have to petition, which is the applicant. You do a petition or an application. It's called various things in different jurisdictions for the rezoning. And as part of that application process, you have to provide notice to the public that you're applying for the rezoning. You are entitled to a public hearing, and the governmental body that has that hearing makes a decision. And then if you don't like it, you can appeal it. Usually there's a right to appeal set out in the zoning ordinance. And we're going to talk about each of these things now. So I'm ready for the next screen. So in the pre-application meeting with planning staff or during the Concept Review Committee in Atlanta, you have to meet with these planning people before you file the application. And you actually typically go in with your whole application filled out. They want to see exactly what you're planning to do. And you should have it ready as best as you can. You should have everything that you can possibly have ready for that meeting before the planner. And in Atlanta, as I said, you have to go through this meeting with the CRC. And the CRC is comprised of city staff from the building department, the zoning department, the arborist, planning, watershed management, and public works. And you file it, the city's gone to an online system. Well, the zoning online has been up and running for a while, but now they've got a portal for also business licensing and other kind of licensing that just started this year. So now in Atlanta, most everything's filed online. So in those the CRC application process has to go through the city's Excella Citizens Access website. And I put a link to it on the screen, but it's also on the city website. And I'm ready for the next slide. And then when you are going through this process to meet with the CRC, you have to submit a lot of things. As I said, you need to have your application pretty close to being ready. So you have to show them the existing conditions of the property, which means you need to submit a scaled site survey where it shows the topographical and tree conditions of the property in the current state. And you need to give them a conceptual plan, which is your proposed concept, showing where you're proposing to put a building, any roads or sidewalks or site access or grading, stormwater management, landscaping, and that kind of stuff. They're going to be looking at all of that. And then the CRC meets at certain times of the month. I have it up there. I believe those are still current. Although I'm not sure they're meeting in person right now. I think they've gone to in person, but they were meeting by online, by Zoom. But the city has seemed to slowly go back to meeting in person now. And then you're given about 10 to 15 minutes to present your case when you do meet with the CRC. I'm ready for the next slide. And once you get through that CRC process, you hopefully will be in a position to file your application for the rezoning. And every government has their own processes of how you do that. But in Atlanta, you have to submit a summary of your project, of your rezoning project. You submit a documented impact analysis that includes information about these factors: compatibility with comprehensive development plans. That's the future land use map I keep talking about. Timing and development and availability and impact and effect on public facilities and the surrounding community. I'm ready for the next slide. And then you look at also availability of other land that's suitable for your proposed use. And actually, I'm working on a rezoning application up in Johns Creek right now. And my client is a very large company, and they have given, in our package, we will be giving the city of Johns Creek 4 alternative sites that we looked at to move. They're currently operating in Johns Creek, but they want to expand their operations and rezone. And so they're looking at alternative properties to see if there's a better way to do it versus the rezoning in Johns Creek. So we will be presenting all of those other areas that we could possibly go into when we propose the rezoning application. So you also have to show the effect on the character of the neighborhood, the suitability of the proposed use, the effect on adjacent property. That's a really big one. The city or county is going to want to know how your rezoning impacts your neighbors, and the economic use of the current zoning classification. They want to know what can the property be used for right now if they weren't to rezone it. And then they always look at tree preservation. The arborist is always going to be involved because they don't want you to cut down trees if you don't have to. And then they will make you submit a site plan of the property. I'm ready for the next slide. And you have to submit a property description, which is usually a legal description, but you also would want to present a plat or survey. And if there's more than one contiguous property involved, you probably need to submit a consolidated legal description. If your rezoning involves construction of residential units, you will have to, in Atlanta, you will have to fill out an Atlanta public school form, which will detail how many people will be moving in, including families and the number of children, and how it will impact the Atlanta public school system. If your development is of a certain size and density, there's a whole section of state law that talks about developments of regional impact. It's somewhat complicated, and I'm not going to get real into it, but some projects that are very large will qualify to be a DRI. And when that is the case, you have to go through the state before you even can go through the city or county rezoning process. So when you're looking at and this probably doesn't apply to nonprofit organizations, but I guess it could. But if you're in a position where you think it could be a DRI, you've got to go through all these steps before you rezone. I'm ready for the next slide. And then the city or county will also want you to look at tree preservation. As I said, you have to comply with the tree ordinance, and you have to have it approved by the arborist. And then you have to also look at the comprehensive development plan to make sure that anything that's required is included. And I think every city and county has a disclosure form where if you, as the owner of the property, or even as the applicant's representative, including the real estate agent or the leasing agent or an attorney such as me, has ever made a financial contribution to a member of the city council or one of the commissioners, you have to submit a disclosure form. If it was more than, in Atlanta, if it was more than $250 in the past 2 years, and you have to show who you made that contribution to, when it was made, and how much it was made for. Now, other jurisdictions have other levels. Some say any contribution, some have a higher limit, like $500. So you have to look at that to make sure you don't not abide by that rule. I'm ready for the next slide. And then in the application, there's an authorization to inspect the premises, allowing zoning staff to go on the property. There are fees always associated with a rezoning application, and the application will tell you what those fees are. There should be a fee schedule. And then you're set down for a hearing date before in Atlanta, it's the city's zoning review board. And in other jurisdictions, it could be called something else. It could be the planning commission for a county. It could be anything else, a board of zoning appeals or zoning adjustment. It varies from city to county. And you should be able to see that in Atlanta. You can see the calendar for the ZRB in the application package. So if you know that you need to meet a certain deadline, that you need to have, like, let's say you're supposed to close on this property at a certain date, you want to make sure you get your ZRB hearing date well in advance of that closing so that you have an answer as to whether you're going to be able to rezone the property or not. So you have to look at that calendar, and then you have to back yourself up and see the various dates for getting doing the CRC meeting, for submitting the application, for providing notice to the public, which we'll talk about in a minute, and just lining it up. But the dates are almost always set forth in an application package. And I'm ready for the next slide. And in Atlanta and most other jurisdictions, you have to meet with your neighborhood community members. So in Atlanta, the neighborhoods are called neighborhood planning units, and there are 25 neighborhood planning units. They are citizen advisory councils that make recommendations to the mayor and city council on all kinds of things, such as zoning, land use, alcohol licenses, and other planning issues, and even about the police department and water issues. They talk about all sorts of stuff. Sometimes they are required to take a vote and make a recommendation. Sometimes they're just listening and getting information. So in this case, they actually vote on it. So each neighborhood planning unit is also comprised of neighborhood associations. And each of those associations are their own entity. Well, they're not entities, but they're organizations. And they meet amongst themselves too. So typically, when you're an applicant in Atlanta, you have to meet with that smaller neighborhood group before you meet with the neighborhood planning unit, because you want your neighborhood, your immediate neighborhood, to be on board with what you're proposing. So interacting with that smaller neighborhood is very important, so that they understand what you're planning to do, and you want them to be able to go to the neighborhood planning unit and say, yes, we support them. And once your application is filed, the applicant for rezoning must appear before the NPU to get the NPU's recommendation. I'm ready for the next slide. The NPU usually requires that the applicant, as I just said, the applicant meet with the requisite neighborhood association, and sometimes they make you meet with two. I have a client right now who borders two, he's on the border of one neighborhood association and the other one's right across the street from him. So the city council member for that district has asked us to meet with both neighborhood associations, which we're doing. So you just have to figure out which neighborhood association you're in and which NPU you're in to move through that process. And the NPU decision is a recommendation. It's not a final decision. It's not a required decision. It goes to the city council. Well, first it goes through the ZRB, which is the zoning review board, for the hearing on the rezoning application. And we also have to look at what the planner's recommendation is. So remember, I said you meet with the planning staff before you file your application. You kind of can get an idea of whether they're going to support this application or not. But they actually put together a formal report. And sometimes you don't get that report until maybe a week before the hearing, or even sometimes the day before. So you have to kind of be on top of the planners to see if you can get the report. But you want to see what that report says, because the planner sets out the entire application, all the departments that have reviewed it, and all of their comments, and then it makes its own comments about whether it supports the rezoning application, or if it supports it with conditions, or if it just flat out does not support it. And that's extremely important to know before you head into your hearing. I'm ready for the next slide. So in a rezoning application, you also have to provide notice to the public about the fact that you have filed this rezoning application. And in Atlanta, there's 3 ways you have to do this. You have to publish it in the newspaper at least 15 days before the hearing. You have to post a sign on your property at least 15 days before the hearing. The city actually prepares that sign, and then you post it on the property. And you usually go get it and put it on your property. And then if you don't abut a street, there's actually a provision that says the sign can be waived. And then you also have to mail it out. You have to mail a letter out to people who are within a certain number of feet from your property. And in Atlanta, it says 300 feet. In other jurisdictions, sometimes I think in Cobb, it's 500 feet. So sometimes it's a lot more people. So in Cobb, if it's 500 feet, it's more people that you have to notify. But it has to be done a set number of days in advance. And in Atlanta, it's 14 days. And in other jurisdictions, it's other days, other amounts of time. So you have to do that too. And then you have to certify that you did that. So the city's going to be looking at whether you did all of these things to make sure you provided proper notice to the public before they'll let you go have your hearing. Okay, I'm ready for the next slide. So at the public hearing, once you've done all those things, you go to this hearing before the zoning review board and you present your application. And it's a public hearing, it's open to anybody. And then the ZRB hears the recommendation from the NPU, the neighborhood planning unit, and the planning department. And then they also hear legal arguments. Well, hopefully you are taking an attorney with you. That's, I'm going to talk about that, but I wrote up their legal arguments because you want to have grounds for why they should support this application and not disprove it. So the ZRB will take comments from the public, either in support of or against it. And then at that hearing, and this is why it's important to have an attorney with you, as I said, you want to present legal argument, but you also have to make certain constitutional law objections, because if you don't make them at this hearing, you cannot later bring them up in an appeal if you were to lose this rezoning. So in a case where you've already bought the property or you've already signed a lease agreement and you have a lot of money or other interest involved with this, and you have to get this done. And if you get denied, or if the board puts conditions on their approval that you don't like, you might want to appeal it to court. But if you don't make certain constitutional arguments at this public hearing, you're barred from ever raising those in court. So it's extremely important to make those constitutional objections during the public hearing. Okay, the next slide, please. So the government body will make a decision, in this case, the ZRB at the City of Atlanta, and they have to make it in writing. And it's either going to be a favorable decision, an unfavorable decision, or a recommendation with conditions. Now, these are recommendations, they're not final decisions. And then the ZRB decision goes to the City Council in Atlanta. And the City Council reviews the rezoning application. It also hears from the planning. There's almost like a whole new hearing at the City Council. They discuss what happened at the ZRB, but they will hear from the planning department, and they will hear from the public on it. And they will look at what the NPU recommended. And they also they're supposed to look at the record of the hearing before the ZRB and the recommendation of the ZRB. And then they take a vote to either approve it or deny it, or to interject in. They can also put in conditions if they want to. So, the City Council is the final body that makes a decision on these rezoning applications in Atlanta. And it's usually similar in cities. It's the City Council typically. In counties, it's the Board of Commissioners. Okay, I'm ready for the next slide. And there are some limitations on how many times you can file an application for rezoning. Once you've filed an application for a lot or a part of it, no other application for any change affecting that same property or part of it can be filed within 24 months. But there's this applies even if you withdraw the application, but there is a caveat, there's an exception. In Atlanta, the City Council can pass legislation that waives that 24-month waiting period. So if you've applied to rezone property and then you withdraw it and somebody else wants to move forward with it at a later date, let's say you sell the property, and somebody else comes in within that 24-month period, they can go to the City Council person and ask if that council person will support a waiver legislation to exempt the 24-month waiting period. But that doesn't mean they will. I mean, they don't have to. And sometimes these things get very political, so they may not. And also the city can also make amendments and deal with the property at any time that they want to on their own initiative. But once there's final action on the property, so let's say the rezoning was denied or there was conditions placed on it that are not favorable to the applicant, there's a 12-month waiting period before you can rezone, submit a rezoning application again in Atlanta. This is in Atlanta. Okay, I'm ready for the next slide. So you can appeal a rezoning decision. You have the right to appeal it, whether the code says so or not, but most zoning codes have a provision that says how you're supposed to appeal it. And Atlanta does have that. And anybody who's aggrieved by the decision can appeal. So even a neighbor who doesn't like the decision can appeal. So if you get the rezoning approved and the neighbor doesn't like it, they can appeal, but they have to show that they have standing to make that appeal. They have to show that they have some injury that's unique to them that is grounds for the appeal. And the government can, even the City of Atlanta, if let's say the City Council rezones the property, but the planning department's really unhappy with it, the city could appeal. So anybody can appeal who's got standing to appeal, and it has to be done within 30 days of the date of the decision that's being appealed. And in Atlanta, you have to file your appeal in the Superior Court of the county in which the property is located, and it's got to be done in a certain way. The code dictates how it's to be done. So I'm ready for the next slide. Now we're going to move on to other kinds of changes to property regulations. So now we're going to talk about variances and permits for specific uses. And I don't even know how much time I have left, but this will probably take me about 10 minutes. So variances are the grant of authority to use property or to construct on it in a manner that is prohibited under the city's or county's zoning ordinance. So you're trying to do something that is not allowed. And a variance, if you get it, if you're approved, runs with the land. So once it's granted, it can be used by the next owners for here to eternity. The grant of a variance is not legislative. It's called a quasi-judicial decision made by an administrative body. And in Atlanta, it's not the zoning review board that we just talked about. It's the Atlanta Board of Zoning Adjustment, the BZA. So the city of Atlanta actually has two bodies that hear these kind of cases, but the BZA is the one that hears variances. In Sandy Springs, they call it the Board of Appeals. So every jurisdiction has their own body and laws about how these applications are heard. I'm ready for the next slide. So these kind of the variances are applications to change things like area and dimensions, the way a property, like if you don't like the existing dimensions or physical requirements under the zoning ordinance, and you want to reduce some dimension, like a yard setback or buffer size or the height of the building. If you want to make a fence lower than what it requires, or even make it higher than the requirement says you can, this is how you get there with the variance application. There's also use variance applications. So these are for when land is not, you can't use your land in a certain way, the use you want to use is not allowed. You can try to get a use variance. Most cities and counties do not like these, and the planners do not like these. The city of Atlanta prohibits obtaining use variances where the use is prohibited unless it's otherwise expressly stated elsewhere in the code. So there's a general prohibition to getting a use variance, but some counties or cities might allow you to do it. It just depends on the jurisdiction. I'm ready for the next slide. And there are certain criteria for granting a variance, and these are typical for most cities and counties. You have to show extraordinary and exceptional conditions pertaining to that specific piece of property, such as the size, shape, or topography are limiting, and you can't do what you need to do. You can't meet the setbacks or the other kind of dimensional things that we mentioned earlier. There's certain things you cannot do on that property without getting a variance. And then you have to show that the application of the variant of the zoning ordinance regulations are going to create an unnecessary hardship for you as the property owner or the user of the property. You have to show that the conditions are unique to that particular piece of property. So they don't apply to all the neighbors around you. They're just specific to your property. And that the conditions are not the result of any action taken by the property owner. So you didn't cause the conditions to exist. They're there because that's how the property was in that state when you got it. So, and you also have to show that relief, if granted, will not cause substantial detriment to the public good. So you have to show you're not going to hurt your neighbors and cause a negative impact on their property. Okay, I'm ready for the next slide. And there's a whole application process for doing a variance application. It's very similar to the rezoning application process. You have to file a complete application. I'm going back to Atlanta now. You have to file a complete application at filing or they won't accept it, and there can't be anything missing. You have to get a referral certificate from the zoning department, which tells, it's a certification saying exactly what kind of zoning you have. So you actually pay for that referral certificate, and it will give the type of the zoning category and certify that. And then you have to write a written legal description or a plat of the survey and submit that. You have to submit a site plan showing the existing and proposed conditions, which would include the footprints of the building, parking, curb cuts, driveways, streams, buffers, floodplains, all of that. You have to submit elevation showing how you're, when you're building a building out, when you have to show what the buildings are going to look like from all the sides of the building. It's not always required, but most of the time it is. And you have to submit a written justification or legal analysis addressing each of the criteria that I mentioned before, and what is your basis for seeking this request. And that's why a lawyer is important in this situation as well, because that's the key to this process, is submitting and stating why you want to get this done and what legal grounds you have to get it done. Ready for the next slide. There are fees involved, and those should be set out in the application when you file a variance, and same for rezoning. All of these applications require fees. And then there's a schedule for the BZA hearing, just as there was for the ZRB hearing. You have to meet with the NPU, same thing we talked about earlier. You want to make sure your little neighboring organization is on board with you. So you want to meet with them first, and then you want to notify, you've got to notify the NPU, and there's a process for doing that, so that you can get a recommendation from them. And then you have a public notice, same thing as before. You've got to do the written notice to the property's owners within 300 feet of your property. You have to put the notice in the newspaper, and you have to post a sign. Okay, ready for the next slide. The staff does a recommendation, just as it did in the rezoning. Typically, these are not ready till the day before the hearing, before the BZA hearing. Other jurisdictions do make them available sooner, but you want to try to get it as quick as you can. And if you're going to make any kind of amendment to your application, you have to do it at least 18 days prior to the hearing, or your hearing is going to get deferred. And you can ask for a deferral once you know you've got issues, like if you need to make an amendment or something's popped up, there's opposition to the application, or the city council person wants to talk to you about it, or whatever it might be. You can ask for a deferral. You have to do it in writing prior to the hearing, or you could stand up at the hearing and ask for it, but sometimes they don't grant it, and you are assessed a fee if it's at a certain point in the process. If you're placed on a consent agenda where the NPU has approved it, you can get placed on a consent agenda, and the BZA might approve it without even discussing it. But sometimes somebody might pull it off of the consent agenda because they've got some question about it, and they will discuss it and take a whole vote on it. So you never know exactly what's going to happen. I'm ready for the next slide. And then you can appeal it as well. You have to do an appeal within 30 days. In Atlanta, you have to do it in the Superior Court, as I said earlier, where the property lies. And you have to do it, as I said, in 30 days. And each county and city has their own processes. So when you're in a different city or county, you need to understand their processes and what their requirements are about appealing. And as I said before, any person who's aggrieved, who can show special damage that they've somehow that they've been injured as a result of this decision, or they will be injured, they have to show standing to file an appeal. So that would be your neighbor, or the city itself, or somebody else. It doesn't even have to be an immediate neighbor. It could be anybody. I'm ready for the next slide. And then there's a category of other items that you can get for your property called special permits. And each city and county has their own terms, which they use for these permits, but most of them do the same thing. They're permits that are granted to the landowner through an administrative process, which allows the property or a building to be used in a manner that is not allowed by right under that county or city zoning ordinance. And there's case law, a big case called City of Atlanta versus Wansley Moving Company that laid out some information about special permits. And it's a zoning vehicle, which provides a mechanism for local governments to be flexible. So even sometimes the city or county doesn't like the way their codes read. A city council person might want something to happen in their district that is prohibited by the zoning code. So special permits allows that flexibility to offer a landowner another use, possibly. I'm ready for the next slide. In Atlanta, there are 3 classes of special permits. There's special use permits, there are special administrative permits, and there's special exceptions. Other cities and counties sometimes call them conditional use permits, and some issue special land use permits, SLUPs. So there's CUPs, there's SLUPs, and there's SUPs, and there's SAPs, and there's special exceptions. And special use permits in Atlanta require a hearing before the ZRB, which is the same body that hears rezonings. And they follow that same process where they have to go through the recommendation by the ZRB to the City Council, and they're intended to be used in connection with uses of substantial significance or of unusual operational characteristics. So that's why the ZRB gets involved with special use permits. I'm ready for the next slide. Special administrative permits in Atlanta are approved by the Bureau of Planning Director, and they don't require notice or a hearing. And sometimes they get approved before a neighborhood even knows it happened. SAPs are intended to be used where complex or unusual technical determinations are involved and are in conjunction with temporary uses and structures. So a lot of times he's come into play with building renovations in Atlanta, but this does not require the public to get notice of it or to attend a hearing. Okay, I'm ready for the next slide. And then special exceptions, they use the same application process as variances do. They're decided by the Board of Zoning Adjustment after public notice and hearing. So special exceptions have to have that notice and hearing for the community to come talk about it. They're used in conjunction with cases where consideration of effects on the surrounding property is of principal importance. And the BZA is authorized to waive or reduce parking and loading requirements in any of the zoning districts when the character, and that's why special exceptions are used mostly for waiving or reducing parking and loading requirements. And so they will do this when the character of the building does not require the full regulation or restrictions of parking or loading facilities, or where the full regulations would impose an unnecessary hardship on the use of that property. Okay, I'm ready for the next slide. And then there are also administrative variations in the City of Atlanta. It's not a permit, it's an authorization through the city's planning department to deviate from regulations upon a written finding that the plan that is being submitted satisfies the public purpose and intent of the regulations, and it does have an aspect of public protection. It's not going to be greater than necessary, and it's not going to harm the public. And in the case where strict application of a specific regulation is not necessary to accomplish public purposes or protection, if you can show that, you'll most likely get an administrative variation. Ready for the next slide. These are examples of applications in the City of Atlanta and where they go. So like at the top, I've got the Board of Zoning Adjustment, then I've got the Zoning Review Board, and then I've got the special administrative permits that have, those are things that fall within those jurisdictions. I'm not going to read them all. I'm ready for the next slide. And there are special permits in other jurisdictions, as I said. Everybody calls them different things. In Forsyth County, I've been dealing with some property up there the past couple of years, and they call them cups. And they also require sketch plats, which the City of Atlanta does not require. And a sketch plat provides the director and the Board of Commissioners with an opportunity prior to the construction or build out of a proposed development to review a site plan of the proposed subdivision or land development to make sure it's in compliance with the zoning code. And it also lets the public come in and make comments about it. I'm not going to read all of that, but sketch plats are important in Forsyth and in some other counties. I'm ready for the next slide. In DeKalb County, they call them SLUPs. And in order to get a beer and wine retail package sales license or a gas station or fuel pump license, you have to get a SLUP, which is unusual. That's not the case in the City of Atlanta. You just have to get the license itself, but you don't have to get a SLUP. Sometimes you do sometimes have to get a special use permit for a gas station in Atlanta. Everybody's different, so you have to really know the code. You have to look at the codes. And DeKalb has certain exemptions that will allow waiving the need for a SLUP. So you have to look at those things. City of Sandy Springs also calls them a cup. Cobb County has special exceptions, and they issue certificates of special exception when conditions relating to a special exception have been met. I'm ready for the next slide. And so I'm at the end. In summary, you have to thoroughly understand the property before you commit to a lease or sales agreement, or even when you want to use a property in a certain way, or when you're accepting a donation of a certain object to be used on the property. And I have a sample that actually helped a client of the pro bono partnership. A woman who runs a pantry was given a trailer, a big trailer. It was fabulous. She wanted to use it on the property, and the city came out and cited her for violating zoning code sections. And I helped her get through all of that. But it was a problem. It caused extensive expenses for her and a headache and stress and all of that. So don't accept a donation of anything for your property before you know if it's allowed, if it's legal. And don't sign a lease and don't sign a purchase agreement for your property unless you know it's legal. So in determining that, you have to determine, as I said earlier, your jurisdiction. You have to look at your zoning classification. You have to look at whether the law under that zoning classification allows your use. And if they don't allow it, then can this property be rezoned, or do you need some kind of other permit, like a special use permit, a special exception, a variance, a SLAP, a CUP, to make your use work on that property? So in determining that, you have to assess your factors that are always going to be there: community opposition, surrounding uses, political climate, the traffic patterns, the building design, public safety, property values of surrounding properties, and other factors. And you have to look at all of this to determine if you should proceed with trying to get zoning relief. And finally, if you don't get what you want, are you going to appeal it? And do you have the grounds to appeal it? Have you made all your objections? Have you submitted the justification during the public hearing portion and in your application to allow you to proceed with an appeal? That is it.
Wow, Lisa, that is a lot of information, and it was great information. Thank you so much for sharing that with us. For our viewers, if you have any more questions, please feel free to type them in the chat box. And to start off, Lisa, I did have a couple of questions. First, about NPUs. Do those only exist in the city of Atlanta, or are there in other parts of Metro North Georgia?
Well, there are only NPUs that I know of in Atlanta. It's in their code. They have it set out in the code. It's called a neighborhood planning unit. I can't think of another jurisdiction that has neighborhood planning units, but most jurisdictions do make you go to the community. For instance, I did a rezoning for a Muslim synagogue, not a synagogue, but a church. And we had to meet with the Mableton Improvement District, which is similar to the NPUs in Atlanta. But the Mableton Improvement District was made up of a bunch of community people, and they were really stringent about what they wanted this property to, what the owner to do and how we were to proceed with it. And we had to come up with a stipulation letter. We came up, and it was very strict, but we got it done. I mean, we got the rezoning done, but there are not, I don't know of other jurisdictions that actually have a neighborhood planning unit, but they might have other neighborhood organizations that they call something else. But I don't know of any that has the same process that the city of Atlanta has with neighborhood planning units.
Okay, yeah, that makes sense. And can you give us some idea for a nonprofit that receives a citation? What are like kind of the first steps that they should do once they receive that citation?
Well, in the case I mentioned before, the woman did get citations, and I went with her to court actually several times, and I tried to work with the solicitor, appealing to the fact that this was a nonprofit that didn't have a lot of money to deal with, and that she really didn't understand the laws, and she had been donated this beautiful trailer. So you really should get an attorney involved, and I know that can be expensive, but in the long run, it does save you money, because you don't want to keep doing something that's going to continuously get cited, and you don't want to continuously be in court. So you need to know what that city or county is telling you. You need to understand what they're saying you're doing wrong. And if you can correct it without much problem, then do that. But if you can't correct it, you really do need an attorney to help you shift through the process to try to, get a zoning change if you need one, because you don't really want to go to court. If you go to court and get cited, fines can be assessed. You can even end up in jail, but they don't typically do that. But that's a penalty, that the city or county can enact. So you really want to take a lawyer with you if you get cited, so that they can help you sort through whatever the issue is.
And my next question has to do with the GIS maps that you referenced at the beginning of the presentation. Can those be found online just by like Googling, for example, GIS DeKalb County?
Every county and city has it in a different place. So what I do is I go into the county, like I'd go into the DeKalb County website, and some are easier than others to maneuver. But if you can put in the words GIS, it might pop it up. Sometimes they're hidden in their planning department section or in their zoning department section. They put them in all different places. And since I deal with Atlanta a lot, I know exactly how to go there. And in DeKalb too, I'm handling something in DeKalb right now, and Cobb. So once, if you do it on a regular basis, you know how to get into it quickly. But typically you've got to go into their website. I don't know if you might be able to put in GIS and see it pop, DeKalb, and see it pop up immediately, but I just always go into the website of the county or city to see if I can find it there first.
Okay, well, I think that is it for our questions for today. If there are any more, feel free to put those in the chat box. Wait a couple minutes. Well, I'm not seeing anything else come up, Lisa. So that's it for this installment of the Pro Bono Partnership of Atlanta's monthly webcast series. Lisa, thank you so much for speaking with us today. And to the nonprofits who have tuned in, thank you for watching. If you're interested in keeping up with PBPA, please sign up for our newsletter or follow us on social media. We have all sorts of helpful legal tidbits for nonprofits there. And please share your feedback with us with that survey link I put in the chat box. We really do value your thoughts and ideas, and we use it to inform our content going forward. Have a good day, everyone.
Thank you. Somebody wants